they diminished the abuse, and he called it the abuse excuse.
Brothers Erik and Lyle Menendez hoping to be released from prison or get a new trial for the murders of their parents after bombshell claims that new evidence proves their father sexually abused them. But the prosecutor on the case isn't buying it.
This is not a manslaughter trial.
Erik and Lyle were not victims.
Welcome to Crime Fix. I'm Angenette Levy. In the mid-90s, aside from the O.J. Simpson case, there was probably no bigger case than the trial of Erik and Lyle Menendez. The brothers killed their parents, Jose and Kitty Menendez, at their home in Beverly Hills in 1989 and claimed burglars did it. Erik and Lyle went on spending sprees after their parents' murders. They were charged in 1992. The first trial ended in a hung jury, the second in a conviction and life sentences. Nearly a year ago, attorneys for Erik and Lyle filed a petition for a writ of habeas corpus, saying new evidence shows they should be freed or get a new trial. They always argued that they were guilty of manslaughter and not murder. The evidence that the brothers cite includes a claim from Roy Rosello, a member of the popular 1980s boy band Menudo, coming forward to say that Jose Menendez raped him as a child. Menudo was represented by RCA Records at the time, where Jose was an executive. The prosecutor on the murder case, though, says she doesn't believe it to this day. She spoke with Fox Nation in a new 4-part series, Menendez Brothers, Victims or Villains, that was just released.
I put on the fact that these two yahoos killed their parents. And I put on the fact that they killed them in cold blood with premeditation. And the facts in this case are irrefutable, except for the ones about Jose being a child molester, which I still, to this day, after 34 years of thinking about it, I don't buy it. But not at all. Let me say this. I did a preliminary hearing with Leslie Abramson 5 years before this case, and in it she was saying that her client was in fact a victim of domestic abuse. But as soon as she came on the case, I know, oh, okay, she's going to turn them into victims, because that was her MO.
There you go. The Menendezes are adamant that they were the victims of abuse and cite a letter they say Erik wrote to their cousin Andy in 1988 detailing the abuse. Attorney Mark Garrigus is part of Erik and Lyle's defense team. I spoke with him last year about this case.
But we're hoping to at least get a hearing or an order that will give us a hearing. And somebody much more clever than me said, think about this. If this case from the 90s was tried today, do you think for a minute that somebody would exclude the abuse? It wouldn't happen. Victims, for the most part, all of the relatives are supportive.
So what chance do the Menendez brothers have of actually being released from prison or being resentenced? Joining me to discuss this are two California lawyers. Josh Ritter is a former prosecutor and Lara Yeretsian is a defense attorney. Thanks to both of you for coming on. Josh, I'll start with you on this because full disclosure, as you told me, you were interviewed for this new Fox Nation 4-part series about the Menendez case. So tell me, what do you believe will happen with this? What are your thoughts on the petition?
Well, I think they have strong arguments. This is not something that I would say is without merit. They make strong points as far as, and it's important, I think, to understand the distinction here is that they're not saying these two men are innocent. They're saying they're guilty, right, but they're guilty of manslaughter and that they weren't given the proper opportunity to present evidence toward that. And they said that in the first trial, they hung significantly on that issue between murder and manslaughter. But on the second trial, the judge made significant rulings limiting their ability to present evidence about the abuse, which would have lended towards their manslaughter arguments. And that because of that, the prosecution was given the opportunity to make statements in closing arguments along the lines of there is no corroborating evidence. And their position is that is in fact not true for the prosecutor to have even made those arguments to the jury. So I think there's merit to it. I think the arguments are strong. The problem is where they're bringing this, courts are incredibly reluctant to turn over jury verdicts, and they're incredibly reluctant to go back and revisit things unless they feel that the judge made rulings that are simply not founded and are simply outside of the judge's discretion, in other words. So that's the uphill battle that they have.
That's interesting you bring that up because this is a petition for a writ of habeas corpus. And that, just so our viewers are clear on that, what that means is you go to a judge, You're basically saying to the prison warden, bring us the body. That's what it means. And you're saying this person is being held unlawfully. And this was filed in state court and not federal court. So, Laura, do you have any opinion on why that happened? Because a lot of times we see these filed in federal court.
In this case, I'm assuming we've got Cliff Gardner, who's a very experienced appellate lawyer. He usually the writ of habeas corpus that I know of, he brings them in state court. At least I've seen that in the Scott Peterson case. He must have thought that that is the place to do it, and I would defer him on that because he's the expert and the professional on that. In this case, in addition to what Josh was saying, as far as what arguments the district attorney made. They're also alleging that there's new evidence in this case that they've discovered since the convictions, including some of them are very damning as far as the parents are concerned, including a letter that Erik had sent to his cousin Andy, where he in fact writes about the abuse and how he can't tolerate it anymore, and it almost confirms that it's not so. And that was a letter that was sent 8 months prior to the shooting. And also a new discovery has come up, no information has come up about Jose Menendez, the father of the two brothers, having raped and a singer who was part of a band. So when he was 13 or 14, again, pretty damning. It goes to support the defense argument and defense theory that these boys were molested and sexually battered and raped by their father, and the mom obviously did nothing about it, and they were being abused physically and emotionally by both parents.
Yeah, and that was a member of the band Menudo. When we were all kids, I think Menudo was a really big deal, and Jose Menendez was a higher up at RCA Records and would have had access, the brothers argue, to members of Menudo, and that's how this happened. I think you bring up a good point about this letter, Laura. I mean, there's this letter that Erik is purported to have written to his cousin Andy in 1988 before the murders, talking about this abuse. And apparently this letter wasn't discovered until after the cousin died. So it wasn't even available at trial. So I think that's an interesting point you bring up. Maybe they file this in state court because it's kind of newly discovered evidence, but they do it in the form of a habeas petition. Josh, what do you make of this letter as a former prosecutor? There are some people who always say, you talk about newly discovered evidence, and it's supposed to be evidence that couldn't have been discovered at the time or wasn't available at the time. I don't know. Is this newly discovered evidence from the prosecution's perspective? Because we know they claimed this at the first trial, that there was, mental, physical, sexual abuse. But the letter appears to be brand new.
Yeah, I don't think there's any denying that it would be considered newly discovered. They had looked for as much evidence that they could to support their arguments that they were the victims of abuse at their father's hands. And it was only revealed until much later. The problem is the question before the court now is going to be, well, yes, this is newly discovered evidence, but would it have significantly impacted the juror's decision? Would it have moved the needle, in other words? And I think the prosecution, and by the way, I don't know how firmly they are arguing against all of this, but the prosecution's position essentially is going to be that there was evidence of this at the time. They had made these arguments. The judge made the rulings that they did. And this isn't such significant evidence that you can say that they weren't involved in the killings. It's just more evidence towards the idea of manslaughter. And we don't know if this would have really changed the jurors' minds. It's all of these questions that make it ambiguous as to what the results would have been and if they would have been any different. And again, the courts like finality. They want jurors' verdicts to remain and not to be continually questioned years and years later. So it is strong evidence. I think they had it at the time, it may have made a difference, but that's a different question that's being presented to the court now.
The stories we cover make it really clear that you can get into a jam and need help from a lawyer. That's where a law firm like Morgan & Morgan can help you. Morgan & Morgan is the largest personal injury law firm in the United States with more than 1,000 attorneys. The firm makes it really easy to submit a claim. You can do it in just a matter of clicks using just this, your cell phone. If you ever get hurt, your injury could be worth millions. And taking on a big insurance company is a lot easier when you have a firm like Morgan & Morgan fighting for you and protecting your rights. Morgan & Morgan does not settle for lowball offers. In the last few months, they've had some really big verdicts. In Philly, they won a verdict for $26 million. That was 40 times higher, the highest insurance offer. In Florida, Morgan & Morgan won a $12 million verdict. And in New York, Morgan & Morgan won a $6.8 million verdict. Also, there are 0 upfront fees. Submitting a claim is free, and you only pay if you win. So if you'd like to submit a claim, log on to forthepeople.com/crimefix or click the link in the description or pinned in the comments. So Laura, the first trial ended in a hung jury. And, obviously the first trial, the jury was conflicted. They couldn't reach a unanimous verdict. Different rulings in the second trial leads to murder convictions, and they get life in prison without parole. These brothers are cast as like spoiled brats who killed their parents, and, they wanted the money, and they went on a spending spree, and they were just jerks, and they claimed that the house was burglarized, and they were made fun of on late night TV and on Saturday Night Live, things like that. Had this letter existed from your perspective as a defense attorney, or, obviously it existed, but had the defense had it back then, and maybe cousin Andy, who would have been alive or whatever, had testified, let's just kind of put ourselves back in that position back then. Do you think that would have tipped the scales? It's hard. I'm asking you to speculate a little bit, but it sounds pretty compelling if you've got a letter where you're saying like, I can't take this anymore. Dad is like doing this, and he's molesting me, and I can't take it.
Think about it. You've got a witness who's testifying. You've got a jury at the first trial that's 6-6, right, for manslaughter versus murder. And the 6 were for manslaughter, and I think it was a mix as far as where they were on the rest of as far as the rest of the 6 jurors. You've got a witness who's testifying about what Erik told him when they were young, when they were 13. And you get a letter that backs it up 8 months before the shooting. And this is, they're much older, and he's still complaining about abuse, sexual abuse. That not only corroborates it, it also tells you where he is mentally, right? This individual, Erik, in this case, is still being abused years later. He's still telling his cousin. So this is the second time. It's not just one time, it's a second time. Unfortunately, the cousin didn't remember it. I think it would have been very impactful, especially for a jury that was where you had 6 convinced that this was voluntary manslaughter. You never know. Maybe it would have been, we would have had all 12 on his side. It's hard to tell, but it is very compelling, and it's something that should have been presented to the jury. Now, we know that at the second trial, a lot of things were excluded, and it was a lot more limited. Again, the jury obviously wasn't as convinced on the abuse because they didn't hear as much evidence on the abuse. So imagine them seeing a letter that was handwritten 8 months prior. What the prosecution was going to argue that they planned this 8 months prior. So Erik said, it would have been hard to believe. So the jury would have been convinced. I think they would have at least bought it. Maybe they would have had a few more people on their side. You never know. They could have had, again, a hung jury for the second trial. So it's something that the court should consider. And I think it's strong enough for them to hopefully overturn the convictions.
This is a high profile case. Back in the 90s, aside from OJ, nothing bigger than the Menendez brothers case, right? So it's a big case. A lot of time has passed, though, and we have the DA's office led by George Gascon now. It's a different playing field. So, Josh, just briefly, where do you see this going?
No, that's a really important point that you bring up. This was decades ago, and culturally, as a society, we view this differently. We have had a much fuller understanding about the cycle of abuse and how people behave when they're being abused. Especially, we're talking about a father abusing male children and our thoughts on that. There was a lot of discussion at the time of why didn't they just fight him off? And like you had pointed out earlier, they were subject to a lot of ridicule in the media at that time. I think things have changed significantly, and our view towards abuse and their behavior has changed significantly. I think as a society, we're ready to take another look at this case. The problem is they're dealing with the constraints of the legal system and what they can allow with the arguments that they're making.
Laura, what's your take on that?
Josh may be right on that one, because the legal standards are different than what the society thinks. Yes, we have now as a society, we're more ready to give them a chance, but you've got the courts deciding this issue. And I mean, I've read the writ of habeas corpus. It raises some very good points. Would it be a good idea for them to get a second trial, a third trial, actually? Yes, but are the courts going to agree with us? Can't tell you. It's you never know. You never know. I've seen all sorts of stuff. We've seen it in the Scott Peterson case. Anything is possible. So I'm not going to rule it out.
All right. Well, we can just wait and see. I know we've reached out to the LADA's office several times about this, and they're really not commenting. So Mark Garrigus, I know, was on TV saying that some of the family members of Kitty and Jose are supportive of the brothers' release, of Erik and Lyle being released, and that they've presented that to the DA's office. So it'd be interesting to see what their take is on this eventually. Thanks so much, guys. Appreciate it.
Thank you for having us.
And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with us. We'll see you back here next time.